it. Just so I don't forget to do it after you have started presenting.
Yeah. It goes through all. Okay, perfect.
Hi everyone. I'll just give it a couple of moments just for everyone to join us here today. If I can just ask that everyone just keeps just themselves on mute just for the length of the presentation. Perfect. We seem to have a good few colleagues that have joined us. So
sorry, I had to know something was going funny on my phone there.
Sorry, we'll just I'll just get started now. If I could just ask everyone to just keep themselves on mute just for the purposes of the presentation.
Yeah.
And then
okay. you're all getting.
If I could just ask everyone just to keep themselves on mute just for the purposes of the presentation. And there will be a section at the end where we can open the floor up for discussions and questions. My name is Danielle Curtis. I'm the legal officer for PILA, and we're delighted to welcome you here today. We are joined by Cillian, who's going to facilitate the session, and we're very grateful to him. He is a barrister who specialises in public law and judicial review, the areas of immigration and asylum, employment and equality, social welfare, housing and data protection. And our session today will focus on the very timely matter of the Temporary Protection Directive, which was recently transposed into Irish law. We also, just some housekeeping matters, if anyone gets kicked out of the session for any kind of technical issues, please just rejoin and one of my colleagues will allow you to join the meeting again. And also one of my colleagues will allow you to get in, or if you have any issues and you can't rejoin, just email us at pila@flac.ie and we're monitoring that email address as well. You also would have seen that we emailed out for any colleagues who wish to obtain a CPD certificate for attending the session here today. If you email us afterwards and we can confirm then attendance and then issue a CPD cert to you. So you just need to email us at pila@flac.ie. So with that said, I'll now hand over to Cillian to begin the presentation.
Good afternoon, everyone. I suppose thanks to Danielle for asking me to do this. Obviously there's a lot of interest in the directive and how it works at the moment. I understand that there's, I suppose, a kind of a mixed group of people participating today, you know, practitioners in the area of immigration and asylum law, practitioners from outside that area, as well as people from NGOs and other interested persons. So I'm going to try and keep it relatively kind of basic and straightforward. I mean, it is obviously kind of by necessity a complex area, but I hope it's not going to be overly dense and will be somewhat accessible. I would say as well, I think, you know, it's important to know from the outset that, I mean, whilst the purpose and the topic today on the directive itself obviously primarily deals with the immigration basis for the person to enter the state, as well as the material conditions and the substantive content that arises from that. You know, hopefully the conflict will be as short as possible. But in the event that it's not, you know, many Ukrainians will want to set up businesses, they will enter employment, you know, they will meet Irish people. So, you know, within reason, really, the effect of the directive kind of touches on all areas of life for them here. So I think it's worth knowing from that perspective in itself. I'm just going to try and just do three things. First, I'm very really quickly going to just set out the scope of international protection. So that is refugee status and subsidiary protection, just I suppose by way of contrast to show what I suppose the Temporary Protection Directive isn't. Then I'm just going to look at the scope and the content and the transposition of the directive. And then finally, I'm just going to really quickly flag what I see are some current issues, speaking to people in the area, and potential future issues. And then, as Danielle said, if anyone has any questions then at the end, feel free to ask. So I suppose just to start with international protection, just again by way of contrast. So obviously there are effectively two bases for international protection in Ireland. The first is refugee status, and you'll see there the definition of a refugee under the International Protection Act 2015, which is obviously taken from Article 1A of the Refugee Convention and its protocol. So a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group, is outside his or her country of nationality and is unable, or owing to such fear, is unwilling to avail himself or herself of the protection of that country, or a stateless person who, being outside of the country, a former habitual residence for the same reasons as mentioned above, is unable or owing to such fear, unwilling to return to it. So I suppose a refugee obviously has to have a fear of persecution which arises because of one of the five what are known as nexus set out in that definition. So they're being persecuted because of their race, religion, nationality, particular or their political opinion, or membership of a particular social group, and that can include, you know, membership of the LGBT community, can also include things such as gender. I suppose, you know, reading that, obviously Ukrainians could, of course, fall within that definition, in particular by reason of their nationality. They are being persecuted almost per se by virtue of the fact that they're Ukrainians in Ukraine. As well as that, we also have subsidiary protection, which I suppose in international law is referred to as complementary protection. So a person in respect of whom substantial grounds have been shown for believing that he or she, if returned to his or her country of origin, would face a real risk of suffering serious harm, and who is unable, or owing to such risk, unwilling to avail himself or herself of the protection of that country. And serious harm means A, death penalty or execution, B, torture or inhuman or degrading treatment or punishment of a person in his or her country of origin, or C, serious and individual threat to a civilian's life or person by reason of indiscriminate violence in a situation of international or internal armed conflict. So I suppose the purpose of subsidiary protection is to kind of fill in that area around refugee status. Refugee status is obviously quite specific to a person, and so someone might fall outside of the definition of refugee but still be entitled to subsidiary protection because they fall within the definition set out there. So obviously, if we look at C there, and this arises from Article 15C of the Qualification Directive, you know, Ukrainians, if they are civilians, they seem to have a serious individual threat to their life by reason of indiscriminate violence in a situation of international or internal armed conflict. So obviously, in the premises, Ukrainians would seem to be, in the current situation, able to fall within either or refugee status or subsidiary protection. Now, the process of applying for international protection is obviously very, very onerous. It's much more of it's based on an individualized assessment and application. So typically what happens is that there's a preliminary interview, which is known as a Section 13 interview. Then there's sometimes, you know, there's the formal application itself. They fill in a questionnaire, which sets out the grounds for persecution. There's an interview, a Section 35 interview with an international protection officer. And then the International Protection Office does a report on whether or not they should be given a refugee status declaration or a subsidiary protection declaration. Then obviously if they say they don't, then there's an appeals process to International Protection Appeals Tribunal. So really it's quite a long and quite an evidentially onerous process, and can take, you know, from many months to even many years. So it's quite a long process, and I think it's important to have that, I suppose, as a kind of a base knowledge in relation to the contrast then with temporary protection. So just a bit of background then about the Temporary Protection Directive. So effectively, its purpose, it was motivated by the Yugoslavia and the Balkan War. Originally there was effectively council proposals, European Council proposals to this effect in the early 90s. Then it was originally adopted by the Prodi Commission in May of 2000 and took effect from July of 2001. Ireland has an opt-out in the area of justice and home affairs. So originally was not part of the directive, but then did opt in April of 2003. And so it hasn't actually, until this point, it was never activated. It's never been used at all And, you know, there's a lot of academic discussion prior to this conflict amongst academics about the directive, and many of them actually considered the directive to be almost completely obsolete. They didn't see it as ever, you know, really arising, because the European Union had almost always favored things like relocation or resettlement, relocation from asylum seekers from who find themselves in Italy and in Greece, resettlement from places like Lebanon or Syria of people who've been recognized as refugees from UNHCR. And then, as well as that, things like bilateral agreements between the European Union and Turkey. So I suppose that was really the original, you know, that was the factual basis before. I also have just a few, you know, some numbers there just to kind of throw it into even sharper contrast. I suppose the original Commission estimate of the numbers of persons who would be seeking to avail of protection, whether temporary protection or international protection, was that a possible figure of between 2.5 million and 6.5 million persons will be displaced, of which 1.2 and 3.2 million may seek international protection. And the UNHCR at that time, originally around the time of the 24th of February, estimated that up to 4 million people may flee Ukraine. Now, that number has already surpassed 3 million people, and there's up to 10 million people internally displaced. So even the estimates from just over a month ago are now significantly out of date. The state, I think, originally estimated around 2,000 people. As of last week, I believe it was in excess of 11,000 people. And then they're now estimating it could be anywhere up to 100,000 people. I've also seen the figure 200,000 people thrown around too. There was also some, I suppose, some demographics from last week, and it skews, for obvious reasons, primarily female. So approximately about 70% of the people coming here are female, and also it's obviously primarily for the same reason, women and children. So just, I suppose, to put in a few definitions, just to provide, I suppose, a bit of kind of understanding of the various terms that are meant in the directive. So temporary protection is defined as a means a procedure of exceptional character to provide in the event of a mass influx or imminent mass influx of displaced persons from third countries who are unable to return to their country of origin. In particular, if there's also a risk that the asylum system will be unable to process this influx without adverse effects for its efficient operation. So you can see really there kind of the rationale for temporary protection. It's this idea that if we have so many people looking for protection, the asylum system might be kind of overburdened. It then defines displaced persons as third country nationals or stateless persons who've had to leave their country of origin, country or region of origin, and are unable to return in safe and durable conditions because of the situation prevailing in that country. And then in particular, persons who have fled areas of armed conflict or endemic violence, persons at risk of or who have been victims of systemic or generalized violations of their human rights. And that definition, of course, also refers to Article 1A of the Geneva Convention, which is the definition of a refugee. And then finally, mass influx means arrival in the community of a large number of displaced persons who come from a specific country or geographical area, whether their arrival in the community was spontaneous or aided, for example, through an evacuation program. So obviously you can see there that the definitions as compared with that of a refugee or a person entitled to subsidiary protection are quite broad there. They're much broader. It's capable of encompassing both of those definitions to be a displaced person because of or by reason of a mass influx. So then I suppose just to explain really then how it works, and again in contrast to international protection. So effectively what happens is that the European Commission proposes the existence of a mass influx of displaced persons, and then the Council of the European Union effectively recognizes this or adopts it via a council implementing decision, and this is voted on by qualified majority voting, so a majority of member states representing a majority of the population of the European Union. And this was done back on the 4th of March, and it was done unanimously. So every member state effectively recognized the existence of it. And so then formally then the council implementing decision activates or triggers the protections of the directive, and also sets out then the material scope of who falls within it and who can avail of that temporary protection. So you'll see it says there, displaced from Ukraine on or after the 24th of February 2022 as a result of the military invasion by Russian armed forces that began on that date. A, Ukrainian nationals residing in Ukraine before the 24th of February. B, stateless persons and nationals of third countries other than Ukraine who benefited from international protection or equivalent national protection in Ukraine before the 24th of February. And C, family members of the persons referred to in points A and B. Now, it's important to note as well that under Article 7 of the directive, and this is referred to in recital 14 of the implementing decision, that member states, if they so choose, can actually extend the personal scope of who can avail of temporary protection. So if Ireland wishes, it can give temporary protection to people who fall outside this specific definition. For example, Ukrainians who weren't residing in Ukraine immediately at that point in time. Article 4 then sets out the temporal scope then. So it's initially for a period of 1 year, and then this extends automatically by 2 periods of 6 months. So for another year, and then it's extendable for 1/3 final year then again by the council by qualified majority voting. And Article 6 then sets out that effectively the period and the protections obviously of temporary protection then can end, they can be terminated by the council if the situation permits safe and durable return and respect for human rights and fundamental freedoms, as well as, of course, the principle of non-refoulement, which of course is a peremptory norm of international law. So the prohibition of a return of someone effectively to a situation of ill treatment. So in comparison, just to compare again, international protection with temporary protection, whereas international protection obviously has this individualized application, individualized assessment, provision of evidence to support your application for international protection. In contrast, once a person is able to demonstrate they fall within this scope, they can immediately then avail of temporary protection. So, obviously, I suppose the primary things would be that, you can evidence your nationality, for example, and perhaps also your residence, depending on what the member state wants. But once you do that, then you fall per se within the directive itself. So there is no kind of onerous or long or really any, and I think the Commission considers that there really isn't any application process in itself. So then just moving on, I suppose, to the content of temporary protection. I've just set out a number of things there. So Article 3.1, temporary protection shall not prejudge recognition of refugee status. So that's obviously important because, there is significant and obviously very detailed and contextual overlap between the two things. Article 3.3, the directive itself sets out minimum standards. It's important to remember that. So it only sets out, I suppose, the floor as opposed to the ceiling of what member states can provide. If member states wish to provide more generous provisions, they obviously, of course, can do so. Article 8 then sets out the provision of residence permits, obviously for the temporal scope of the directive, as well as the provision of visas to enable people who fall within the personal scope of the directive to actually get there. And it says that formalities must be reduced to a minimum. Article 9, people who are entitled to temporary protection are entitled to access to information on it in a language that they understand. And then Article 12 and 13 really then are the kind of the important ones. So Article 12 sets out they're entitled to access to employment, self-employment, as well as adult and vocational education. Then Article 13, material conditions, very, very important. The member state shall ensure that persons enjoying temporary protection have access to suitable accommodation or, if necessary, receive the means to obtain housing. Member states shall make provision for persons enjoying temporary protection to receive necessary assistance in terms of social welfare and means of subsistence if they do not have sufficient resources, as well as for medical care. The assistance necessary for medical care shall include at least emergency care and essential treatment of illnesses. And then 13.4, the member state shall provide necessary medical or other assistance to persons enjoying temporary protection who have special needs, such as unaccompanied minors or persons who have undergone torture, rape, or other serious forms of psychological, physical, and sexual violence. And I think that's obviously quite an important one, given the nature of obviously what's happening in Ukraine, and that many of these people would obviously require really the services of medical professionals when they arrive. Then we have Article 14, which is education for minors, and member states may allow adults to access education. Article 15 then sets out that they have rights to family reunification, and this distinguishes between, I suppose, core family members, which are spouses, unmarried stable partners, and then minor unmarried children, and then extended family members, so close relatives who live together as part of the family unit and who are wholly or mainly dependent. Now, the directive effectively says that the core family members are entitled to to family reunification, kind of per se, where it's up to the member state then if they want to extend it to the extended family members. However, as we would have seen from the implementing decision, the council have actually included both categories in their definition of family member under the implementing decision. So both categories do fall within that now, fortunately. Article 16 then sets out what happens for unaccompanied minors. So they have a right to, I suppose, legal representation, for example, via a guardian ad litem, as well as that they should be placed, obviously, with, ideally adult relatives or foster families, if necessary. Article 17 then says, so Article 17 and 19 deal with, I think, really the intersection, the complicated and very complex, and beneficiaries of temporary protection can lodge an application for asylum at any time. Examination not processed before the end of temporary protection shall be completed after the end of that period. And then Article 19, member states may provide that temporary protection may not be enjoyed concurrently with the status of asylum seeker or now applicant for international protection. Where international protection is not granted, member states shall provide for that person to enjoy temporary protection for its remainder. So obviously, Article 17 and 19 have to provide for, the general approach across the member states because it's a directive. So in circumstances where a member state, allows someone to apply for international protection, and if they refused it, they are still entitled to enjoy the currency of the temporary protection period. And then Article 29 says if excluded from temporary protection or if refused family reunification, persons can mount a legal challenge against those decisions. And I would say as well, separately, it would certainly seem to me from looking at the directive that the provisions of the directive appear to be sufficiently clear and precise and unconditional within the rubric of decisions of the Court of Justice of the European Union like Van Gindenloos and Costa, that they probably almost certainly could be relied on directly. They would have a direct effect in the national courts of member states. So then just, I suppose, a few other miscellaneous provisions. Article 11 refers to removal of a person who's enjoying temporary protection from another member state if they go there without authorization. So you can be transferred back to the member state that you enjoy temporary protection from. Article 15 then sets out inter-member state transfers in order to facilitate family reunification. Chapter 4 sets out provisions relating to solidarity, kind of similar, I suppose, to the approach that should be taken in relation to relocation from, originally from places like Italy and Greece, so that the idea that the member states would obviously share the burden of the number of persons seeking temporary protection. Article 28 then just sets out exclusion, so you can be excluded from temporary protection if there's serious reasons for considering that you've committed a crime against peace, war, a crime against humanity, a serious non-political crime. Particularly cruel actions with a political objective can fall within that definition. And then guilty of acts contrary to the principles and purposes of the United Nations. So obviously that would include, say, for example, the crime of aggression, the crime of war itself. Reasonable grounds for regarding as danger to security or convicted of a particularly serious crime and is a danger to the community. And of course, when excluding someone from temporary protection, a member state must ensure that the decision is proportionate. They must weigh up, both sides effectively of the implications of excluding someone and also, the fact that they have committed, something that falls within this scope. Then just, I suppose, moving on then to the transposition then of the directive into Irish law. And obviously this is obviously important for people who, are going to be dealing with Ukrainians, practitioners, NGOs, So this is done under Section 60 of the International Protection Act 2015. And subsection 2 really sets out the circumstances under which someone can avail of the benefits of temporary protection. So Section 60 applies to displaced persons following the adoption of an implementing decision by the Council, who the Minister for Justice gives permission to enter and remain in the state, and who have been registered. So once you've been given a permission to remain on the basis of you falling within the definition set out in the Council implementing decision, and once the Minister has registered you, which I think is done basically simultaneously, then you are entitled to avail of the rest of the benefits under Section 60 itself. Subsections 3 to 5 then deal with exclusion, which obviously I just went through there. Subsection 6 then refers to the provision of a permission to remain to a person entitled to temporary protection, as well as setting out that persons who require a visa to come to the state in order to avail of temporary protection are entitled to a free visa or transit visa. So obviously the Minister has formally waived visas for Ukrainian nationals, but obviously, many Ukrainian nationals would have family members and be in relationships with persons who would be visa required. So for example, nationals of Russia or nationals of Belarus, or Belarus rather, or Moldova. So obviously, there are a variety of family members who would still need to avail of a visa in order to get to the state. And I understand the Minister has now put in a place a kind of an expedited manner of making an application for such a visa. Effectively, it's a long stay other visa. That's the category, and supposedly, the Minister is attempting to process those as quickly as possible. Subsection 7 then says that such a permission granted to remain is for a period of 1 year, which is renewable. The permission is revocable if temporary protection is terminated, obviously by a decision of the Council, and then also if a person is excluded from temporary protection or if they're transferred to another member state. And then subsection 10 then relates really to the material conditions, the substantive content of the material conditions of temporary protection. So the right to seek, enter employment, access to education and training to the like extent in all respects as Irish citizens, receive social welfare benefits and medical treatment on the same conditions as Irish citizens, and the same right of travel within the state as Irish citizens. So it would seem that in many respects, the provisions under subsection 10 are more generous, in fact, than what's set out under the directive. For example, access to social welfare on the same basis as Irish citizens, and of course, access to education per se on the same basis as Irish citizens, not just kept to minors. Now, there is no reference, I suppose, to access to suitable accommodation or the means to obtain housing within subsection 10, unlike in the directive. Now, arguably, one could say that falls within the idea really of social welfare benefits, access to housing assistance payment and things like that. And obviously, of course, the Minister at the moment, I think, is primarily putting people with, either into hotels or emergency accommodation, or obviously placement with foster or not foster families, but I suppose host families or volunteer families. And then finally, then subsection 14. So section 60 shall not apply to a person who is, for the time being, an applicant for international protection, and a permission to reside in the state given under subsection 6 shall not be in force in relation to such a person. So I suppose that's the state availing of its option under the directive not to allow someone to be concurrently an applicant for an international protection and someone who holds temporary protection. It's extremely complicated, I think, and there's obviously incredibly far-reaching implications for persons who either were applicants for international protection or would like to be applicants for international protection who fall within the scope of temporary protection. It's really, really quite complex, because obviously, and I'll speak about this very briefly at the end, obviously the rights or the entitlements that accrue to you being an applicant for international protection differ significantly to a person who provides temporary protection. So then just to run through, I suppose, some current and potential issues as I see them, just very, very quickly. Obviously, the first one, the one that we're kind of seeing at the moment is visas. So obviously, people are fleeing from Ukraine to countries that border on it, like Poland or Moldova. And whilst Ukrainians can obviously come here potentially quite easily because there is no visa entitlements, that's obviously more difficult for visa required persons. It could be perhaps considered whether a similar approach could be taken to core family members, such as spouses or children, that's taken to qualified family members of European Union citizens under the free movement regulations. So this idea that you simply would, once you're accompanying them and have evidence of your relationship with them, that will be enough, rather than having to apply through some sort of formalized visa process. International protection then, as I said, so I suppose the intersection between section 60(14) of the Act, as well as articles 30, 17 and 19 of the directive, as well as now since then, article 18 of the Charter of Fundamental Rights and Freedoms, which is the right to asylum, which only arose through the Charter. So obviously post-dates the directive itself, and whether that changes things is very, very complicated. Obviously, if you are a person availing of temporary protection and wish to apply for international protection, that obviously has significant consequences for you, and vice versa, and really should only really be taken, I suppose, on foot of legal advice from a solicitor practitioner who works in the area. Obviously, if you are already an applicant for international protection and want to avail of temporary protection because it's more beneficial to you, obviously there could be implications for you further down the line if you need to reapply for international protection, which is obviously something that I think will really need more clarity. And the department, of course, is encouraging people to avail of, if they haven't either availed of temporary protection or haven't applied for international protection, to avail of temporary protection, because obviously it's significantly more advantageous immediately, really, in comparison to international protection. But of course, there could be reasons why someone would want to avail of international protection too. The department has also said that it's, it will take into consideration the fact that it's strongly encouraging persons to avail of temporary protection if they withdraw an international protection application. But obviously, very, very close attention and close thought should be taken when considering those things. Expiration then. So once the period of temporary protection elapses, so as I said, hopefully we won't get to that 3-year period and things will have stopped well in advance of that. But if we do get to that full 3-year period, there really is no further provision for an extension under the directive. The process needs to start all over again. So the Commission needs to repropose the existence of a mass influx of displaced persons, and then that would need to be re-recognized or re-adopted by the Council to start it all over again. And then finally, I suppose, as I said, hopefully it won't last necessarily as long, and undoubtedly the number of Ukrainians who come here initially, once conditions are safe for them to return, will want to return, of course, but some people might wish to remain. They might have set up businesses, they might have met someone. So I think it's important for us to, I suppose, practice not only curative medicine, but also preventative medicine, and anticipate some of the issues that they might have in the future. So obviously, one of them could be potentially the reckonability of their permission whilst here under the temporary protection permission for citizenship, things like that. It would seem to me personally that permission is not excluded, so would be reckonable per se. Again, then as well, the content of their residence here, whether it's considered that they're settled or unsettled migrants, and whether, of course, they have private and family life rights that arise because of that, and I suppose the substance of those rights. Renewal and variation of their permission, if they're given a temporary permission, or they're given a permission rather under Section 60 for temporary protection, if they seek to avail of a more beneficial permission, how do they go about doing that? If they come to the end of the 3-year period, will it be possible for them to vary the conditions of their permission? That all needs to be thrashed out. And I suppose related to that as well then is Article 23 of the directive, which allows minor children education, so obviously, and their parents, and then persons for health reasons, they can stay beyond the temporal period of the temporary protection directive, even if it's expired. So there is a certain carve out for that, which is provided. So then just finally, I suppose, just to run through a really, really quick kind of contrast of temporary protection and international protection. So temporary protection is almost quasi-declaratory. So once you can demonstrate to the member state that you fall within it, you can avail of it. Whereas international protection is obviously, of course, more of an individualized application and assessment. Temporary protection is immediate access to employment, so you can work straight away. Whereas obviously, for international protection, that only arises after 6 months. And of course, again, assuming that you haven't gotten a final decision on that. Temporary protection beneficiaries have access to social welfare on the same basis as citizens, whereas those who are in direct provision have access to the daily expenses allowance, $38.80 per week per adult and $29.80 per child. And it seems as if I believe that supplementary welfare allowance has been provided to Ukrainians. Obviously, for other substantive social welfare entitlements, there is the application of the habitual residence condition. You know, it seems likely that something will have to be done about that, because otherwise Ukrainians would be really excluded from a host of social welfare benefits. So then permission, so temporary protection beneficiaries up to 3 years scope, which of course is terminatable before that. Whereas, and you know, we don't know how that's going to play out subsequently. Whereas if you're a person who's been given, if you're given a temporary residence card as an applicant for international protection, that obviously extends for the period of your application process. And then thereafter, if you're given refugee status or subsidiary protection, then you're given either a 3 or a 5 year permission, which is renewable. Passports, then beneficiaries are obviously of temporary protection are entitled, you know, remain nationals of their state and keep their national passport. Whereas obviously, for the purposes of applying for international protection, you give your passport of your country of origin to the International Protection Office, and then ultimately, you know, if you were to use your passport as a refugee, then ultimately you might imperil yourself and put yourself at risk of losing your refugee status. Temporary protection beneficiaries have, you know, wider family reunification per se under the directive, whereas international protection applicants, you know, have certain core family reunification entitlements within 12 months. And then the period of permission then for the temporary protection directive is 1 year renewable. And then for refugee status and subsidiary protection, or sorry, the other way around, is initially 3 years for subsidiary protection, 5 years for refugee status, which is again renewable thereafter. And then, as you know, finally, accommodation, temporary protection beneficiaries are being placed currently in hotels and with volunteer families and emergency accommodation, whereas applicants for international protection are placed in direct provision centres or emergency accommodation, or obviously if they can find their own and can afford their own private accommodation, they can do that so too. Finally, then, there's just a few resources there that might be of use to people if they're interested in more about this. The Commission has some, you know, quite interesting operational guidelines for the member states, the implementation of the directive and the implementing decision, which are worth a read, I think. It also has an information note for people fleeing the war in Ukraine, kind of a central hub on information, which could be of use too. The Department of Justice obviously as well maintains its own FAQs and has an information page. And then the Irish Refugee Council has an information note that it was compiling, which I think was very, very good at a time when really it was very unclear what was happening. So I'd really kind of, you know, emphasize these resources to people too, if they're interested in reading more. But yeah, that's effectively it. I mean, I think I've been talking for ages now, so I hope it was in some way accessible and in some way clear, but obviously there's a lot of content there. But yeah, if you have any questions, as I said, feel free to let me know. So thank you.
Perfect. Thanks so much, Cillian. We really appreciate your time and for running through. It was like a really good session, very informative presentation. If anyone has any questions, you can just unmute yourself and jump in. I think there's a question there. in the chat box, Cillian. Could you address briefly what happens where a person who's eligible for temporary protection decides instead to apply for international protection in terms of their status/rights? Also, it was my understanding that while the directive allows the application of the Dublin regulation, the implementing decision disapplied it so Ukrainians can move to another member state, with the caveat that a person can enjoy temporary protection in more than one member state, so would have to arrange for their first temporary protection to be revoked before enjoying it in another member state.
Yeah, I think just to start with the second one first, I think that is correct. Yeah, I mean they've taken quite a, I suppose they're cognizant of the numbers of people and the fact that perhaps many Ukrainians would have family members in member states anyway. So I think they're trying to take it kind of reasonably generously at the moment. Whether that will change or not, I actually don't know, but I think that is correct. In relation to the first question, so if you are a person who currently is availing of temporary protection, and if you choose to apply for international protection, the application in itself by operation of law means that you can no longer enjoy temporary protection. So the benefits set out, for example, under section 60 would cease to apply to you, simply because subsection 14 says that you can't do both at the same time. So the Act, my understanding is that once you apply under section 15 of the International Protection Act, that then stops you effectively from availing of temporary protection, and kind of the benefits of that.
Perfect. Thanks, Cillian. We just have another follow-up question. If a Ukrainian passport holder is here under temporary protection since the war, can they travel to another country for a temporary visit?
Yeah, so I suppose the directive itself doesn't actually make any provision for moving between other countries. I'm assuming the questioner is referring to member states of the European Union. It doesn't actually say that. Yeah, but I suppose, Ukrainian nationals who hold a biometric passport are already separately able to avail of visa-free travel throughout the Schengen area anyway, so they can continue to do that because that hasn't changed at all. So I think it's something like 90 days within a 180-day period they can travel visa-free regardless. But obviously, if they're going to another country that isn't within the Schengen area, it depends on the visa policy of that particular country.
Okay, perfect. I don't see any more questions in the chat, and feel free if you, sorry, Rachel, go ahead if you want to
Sorry, Rachel Birmingham, I'm from Doris here in Limerick. I just had a question. So you were talking about section 60 of the IP Act, and it states there about registration of the permission. Obviously in practice, we're wondering how that's going to work. So some people who have, gotten their letter in Dublin, we're counting that as them registered. But a lot of people outside of Dublin or who were here before that was enacted don't have a letter. And there's questions as well that we're getting from local GNIB about, do they actually have to have an IRP card? So I'm just wondering what, technically, legally, does that registration mean the letter that they're getting at the airport, or are we looking at a situation where they're all going to have to eventually get the IRP card?
So I think the Una Buckley of the department spoke last week, and she effectively said that I suppose ultimately the intention is to give everyone a card, which I assume would act in the same way as the IRP GNIB card. Kind of, I think what they're primarily trying to do at the moment is get everyone in and kind of set them up. And obviously, as you said, I think depending on when in time a Ukrainian national would have arrived, they've either been given this kind of specific permission letter under section 60, or some of them were actually originally given almost like a short stay, type C permission, just for whatever that is, 90 days. And I think they're trying to work their way backwards and get a letter to all those people. But I understand that, I don't know at what point in time, but eventually the intention is to issue to everyone one, I don't know if it's going to be similar to the GNIB card or if it's going to be different. In fairness, I do think the department is taking kind of a pragmatic approach for, say, access to things within section 60. So this registration thing is a bit unclear completely, but I imagine that in a few months, once things are kind of a bit more streamlined about the approach they're taking, they will try and formalize the process that they had been adopting already. But I mean, I can't really speak to that, but I suppose, subsection 2 effectively says that the section itself applies to persons who've been given the permission, who've been registered. But I think realistically, like if you have a permission letter, for example, under section 60, you know, it would be a bit, not saying that it wouldn't happen, but it would be obviously be a bit outrageous for you not to be provided to the material access to the material conditions under section 60.
Perfect. Thanks so much, Cillian. Are there any last questions just before we finish up the session?
Yeah, please. I'll try and keep it quick. So Cillian just alluded to the visa application there. I'm wondering if just through the normal online facility, the regular facility, or if there's a different process. And secondly, if someone is granted a long stay visa, which may have no expiration date or a very long one, if their temporary protection is then expires, what will their status be? Will the long stay visa permission still be valid? Yeah, thanks very much.
Yeah, well, I suppose in relation to the visa application, so I think it's through the Advance website thing that exists already. I think you select a long stay other visa, and then obviously just, you know, you're supposed to set out obviously your basis for seeking a visa to come to the state. And then, you know, well, I suppose once you get here, then assuming that if you are a Russian or a Belarusian family member of a Ukrainian, once you get here on that basis, then you'll presumably be given this section 60 permission, which again is renewable, obviously, at least for the currency of the temporary protection directive period until that ends. Thereafter, you know, it's not clear. I mean, I think the department has said, obviously, they're not going to summarily or forcibly remove people at the end of that permission. Again, this is, you know, there hasn't been anything about what will happen then. I suppose they can't anticipate in time when that will be, nor do they seem to have any publicized, formalized policy in that regard. You know, but I mean, you know, there's so many contextual aspects there. It's hard to know. I would say that, you know, the permission under section 60 simply says it's given for a year, which is renewable. It doesn't necessarily have to tie itself, I guess, to the temporary protection directive period. I mean, I think in practice it probably would, but what they do after that, it's unclear. I mean, you know, I think it really depends on I think they'll have to eventually formalize a policy approach to what it is that they're going to do. But I do think that, I mean, you know, Buckley had said, I think that it wasn't their intention, certainly at this point in time, to create probably more work for themselves in some sort of cliff edge, you know.
Yeah, thank you.
Perfect, thank you. I think we have time for just one more question. If anyone has just another question, just feel free to either stick it in the chat box or just unmute yourself and chime in. No. Well, I just want to extend a really big thank you on behalf of. Oh, sorry. Go ahead. Did I?
One really quick one.
Yeah, of course. Go ahead.
Just because we are getting quite a few questions on it, and carrier liability. I know it was waived, but it doesn't seem to have filtered down through to the actual airlines. So I think there's some confusion there about visa required nationals and what documents are accepted, and you know what happens with carrier liability there. If you have any insight on that.
Well, I suppose, you know, insofar as someone, I mean, obviously Ukrainians don't need a visa, you know, to apply for a visa. So there obviously no carrier liability arises for a Ukrainian because that's now gone. If a carrier were to bring a visa required national who hasn't been issued a visa, I mean, you know, I suppose per se carrier liability would arise there. But I suppose the real sticking point is, you know, the fear of attaching to carrier liability. I mean, if the person has been issued with a long stay visa, that would completely ameliorate any carrier liability, I would say. But I guess if it's not at that point, I do know very early on there was almost kind of a, you know, they were almost telling people to contact the border security or the border team in Dublin Airport or wherever it is, and, you know, try and get them to kind of almost informally clear the person in the absence of, before, you know, they had set up this visa facility, and then ask them to try and contact the airline or something like that. So I can understand why there is some confusion, but I do think now that there is the existence of this more formalized process for a long stay other visa, So I suppose if you have that, carrier liability just shouldn't arise at all, really.
Perfect. Thanks so much, Cillian. And I just want to extend thank you on behalf of everyone here in ECHO. I know some people have sent some comments through to thank you for the session. It was really informative, and also on behalf of PILA, to thank you for your time. And if anyone has kind of any kind of if there are any questions arising from the session, please let us know, and we at PILA can send them out to our lines and see if we can get some answers on them for you if you're in the NGO sector. And with that said, yeah, wish everyone a happy rest of their Wednesday, and take care. Thank you so much.
Thanks so much.